building on our discussion of commission controversies between cross-sale agents. This section explores the lawful avenues available to licensees for collecting earned compensation and clarifies the limited role of the Arizona Real Estate Commissioner in resolving these disputes. Understanding these principles is essential for maintaining professionalism, ensuring compliance with Arizona statutes, and protecting one's financial interests within the scope of the law. In Arizona, disputes over commissions or earned compensation must be approached as civil matters between the parties involved, not as disciplinary or regulatory issues under the authority of the Arizona Department of Real Estate, ADRE. This distinction is explicitly stated in ARS Section 32-2152, which provides that the department and the commissioner have no jurisdiction to adjudicate or enforce collection of private contractual obligations between licensees. Their authority is limited to enforcing the laws governing licensing, consumer protection, and professional conduct, not resolving financial disagreements or contractual breaches between brokers or agents. When a commission dispute arises, the first and most important step for a licensee is to ensure that there is a valid, written agreement supporting the claim for compensation. According to ARS Section 44101, which codifies Arizona's statute of frauds, any agreement for the payment of real estate commissions must be in writing and signed by the party to be charged. This means that a broker cannot collect a commission, nor can an agent collect from their broker without a properly executed written contract. Verbal promises or informal arrangements carry no legal weight and are unenforceable in court. The lawful avenues available for collecting earned compensation depend on the nature of the dispute. If the disagreement is between two brokers, for example, over a cooperative commission split, either party may pursue resolution through civil litigation, arbitration, or mediation. Most professional real estate associations, including the Arizona Association of Realtors, AAR, provide a structured arbitration process specifically designed to handle commission disputes between members. This process allows for an impartial review by a panel of peers, whose decision is binding upon both parties. It is typically faster, less expensive, and more confidential than a lawsuit. If the dispute involves a salesperson and their employing broker, the situation is handled differently. Under ARS Section 32-2155A, all commissions earned by salespersons must be paid through their designated broker, not directly by the client or another agent. The salesperson's right to payment is governed by their employment or independent contractor agreement with the broker. If a salesperson believes they were denied earned compensation, their recourse is to bring a civil action against their broker for breach of contract. A DRE will not intervene, even if the salesperson believes they were treated unfairly, because the dispute is private and contractual in nature. For instance, if a salesperson closes a sale but the broker refuses to pay the agreed-upon split, the salesperson must rely on the written agreement that outlines commission distribution. If no written agreement exists, the salesperson will have difficulty proving entitlement to compensation, as the statute of frauds requires written proof of commission obligations. This highlights why clear, written agreements between brokers and salespersons are vital in avoiding legal complications. A DRE's limited role in such disputes is also reinforced by ARS Section 32-2152B, which emphasizes that the department may investigate allegations of license law violations, such as fraud, misrepresentation, or failure to supervise, but not private civil matters. If an investigation reveals evidence that a broker or agent violated statutory duties while handling commissions, the commissioner may take disciplinary action under ARS Section 32-2153, but this action pertains to the violation itself, not to the collection of money owed. The commissioner cannot order one party to pay another. A well-known example of this limitation occurred in RA ADREV, Davis Realty, 2008, where two cooperating brokers filed competing claims over a commission. ADRI declined to intervene, reaffirming that commission disputes are contractual and must be resolved through arbitration or court. However, the department did investigate a related complaint that one broker had failed to exercise supervision under R4-28-1103A, demonstrating that while ADRI enforces professional conduct, it does not arbitrate financial settlements. When pursuing civil remedies, brokers should ensure that they act within the ethical and legal standards established by R4-28-1101A, which requires honesty, fairness, and integrity. Lawsuits or arbitration should never be used to intimidate or retaliate, but only to enforce legitimate contractual rights. Brokers should also maintain clear documentation of agreements, communications, and transaction details to support any claim for unpaid commissions. To prevent disputes, many brokerages establish internal procedures for handling commission disagreements, often requiring agents to submit written claims to management before pursuing external remedies. This process encourages resolution at the lowest possible level, saving time, costs, and reputational damage. Additionally, maintaining updated independent contractor agreements and confirming commission splits in writing at the beginning of each transaction are essential preventive measures. Review summary. The resolution of commission disputes in Arizona depends on private, civil action, not ADRI involvement. The Arizona Real Estate Commissioner enforces compliance with licensing and conduct laws, but has no power to settle monetary disputes or order payment between brokers or agents. All commission agreements must be in writing under the Statute of Frauds, ARS Section 44-117, and disputes must be handled through arbitration, mediation, or court action. Salespersons seeking unpaid commissions must rely on their agreements with their employing brokers. Written documentation, transparency, and adherence to professional ethics are the best defenses against commission controversies. Discussion prompts. Why does ADRI not intervene in commission disputes between licensees? Answer. Because such disputes are private contractual matters and not within ADRI's regulatory jurisdiction. The commissioner enforces license law, not civil contract enforcement. What is required for a broker or agent to legally collect a real estate commission in Arizona? Answer. A written and signed agreement outlining the commission terms, as required under ARS Section 44-101(7), the Statute of Frauds. What is the most common and efficient way for brokers to resolve commission disputes? Answer. Through arbitration provided by the Arizona Association of Realtors, AR, which is faster, less expensive, and binding. Closing remarks. Real estate professionals must remember that while the commissioner ensures compliance and ethical conduct, the responsibility for protecting one's right to compensation lies in documentation and professional diligence. A well-written agreement, a clear understanding of the law, and open communication can prevent most commission disputes. In every transaction, professionalism should prevail over emotion, and cooperation should take precedence over conflict. The best defense against controversy is preparation, and the foundation of preparation is always a written agreement backed by ethical practice.